Welcome back to the channel and thank you for liking and subscribing. Following on from my previous video about these therapist notes is the duty to report. Now, confidentiality is an absolute fundamental principle in a number of disciplines. Firstly, in the legal profession and in any kind of psychotherapy, psychological therapy session between patient and therapist or professional, and indeed between client and lawyer. The duty of confidentiality is absolutely paramount. So speaking as a lawyer, if I were to breach a client's confidentiality, that would risk disbarment or at the very least severe disciplinary action. However, there is a very important and rather humane exception to this rule, and that is the duty to report imminent and severe harm to another person. So it applies both to clinical and psychological therapists, and it applies to legal practitioners where there is an imminent and serious risk of harm or risk to life of another individual. So in simple terms, if a therapist or a lawyer were in a therapy session or a legal conference with a patient or a client, and they were to speak of previous harm or previous criminal acts, then both the therapist and the lawyer are under a very strict veil of confidentiality of any and all previous harm and acts of violence of any kind whatsoever. They cannot disclose any information gained within a therapy session or a legal conference, regardless of how severe, because of their duty of confidentiality. The only exception, and it is extremely narrow, which applies to both clinical, psychological, and legal professionals, is the immediate and serious risk of serious harm or threat to life of either the client or the patient themselves or a third party. So if a clinical patient or a legal client were to tell you that they are now immediately going to seriously harm another individual or themselves, then both the clinical and the legal professional would be excused in almost all circumstances, in the most serious of cases, from their duty of confidentiality, with the duty to warn and to report serious risk of harm either to the client or patient themselves or to a third party. So with respect to these clinical, legal, or therapist notes, they would be in almost all circumstances if there were an imminent risk and serious threat of harm to themselves or a third party. There would be the duty to warn and the excuse under the confidentiality regime to reveal this information to authorities to prevent that serious harm either to themselves or to a third party, as the case might be. So in the event that any of the information from these therapist notes ends up being revealed in the Amber Heard trial, which I think is a realistic possibility because they've been referred to in this interview thus far, they've certainly been referred to in the sense that she feels that the jury would have been swayed by these notes, despite the fact that I've said that there'll be self-serving statements and hearsay and thus inadmissible and unreliable on both counts in my previous video. If you didn't catch that video, it's linked below because these are two videos in close succession and very closely linked in their content and meaning. On both of those counts, I think these therapist notes have very limited value, if any evidential value whatsoever, and should be taken as such, both as self-serving statements and with hearsay limitations and severe restriction and limitation of any evidential value. And in any event, bearing in mind what I've just said about the duty to warn, if there really were any real risk to herself or any third party, then the therapist would have had a duty to warn authorities as to such risk of harm that was imminent, real, and serious. And in such a situation, one might question the veracity, the validity, and the genuine nature of any such notes. So as always, I wait to see what will be revealed, and I will comment on it as it arises. But in the meantime, please hit the like button and subscribe, and as always, thank you for watching.